its security interest in the collateral owned by Arizona Mills expired when the clock struck 12 on January 31, 2012. The trial judge below was actually the fifth trial judge assigned to this case since it was born almost 10 years ago. She inherited it along with the earlier rulings made by the previous trial judges, including the ruling in 2008, which erroneously interpreted this court's memorandum decision in what we have called Mills 1 to mean that a security interest created by consent may be terminated simply by the passage of time. I'm confident that if the trial court from which this appeal is taken had the benefit of this court's June 21, 2012 opinion, what we have dubbed Mills 2, that we wouldn't be here once again litigating Mills 3. Because as this court explained in Mills 2, where, like here, a security interest exists by consent, the statute 9334F1 provides that the passage of time alone does not defeat the priority security interest in collateral granted by Mills in favor of the trust.
Well, have you found any cases out there that have examined the passage of time? Cases that I've seen suggest that maybe a year or two would be plenty of time, but none of them, they discuss more cars, but not the sort of collateral we're talking about here.
I'm familiar with the cases that you refer to, Judge Portley. Those cases are actually referred to in the comment in 9610, and they're distinguishable in that in those instances, the collateral is held by the party who is asserting the security interest. In this case, the collateral is on Mills' land, and the collateral is owned by Mills. As the court explained in Mills 1, and Judge Portley, you must feel as I do that this is Groundhog's Day, that we just keep doing this again and again. This
must be my karma.
This is both of our third whacks at it. But as the panel, in which of course you participated, said in Mills 1, the UCC approves of this type of transaction where a consensual security interest is formed, particularly with a ground lease, because it makes economic sense and it facilitates the borrowing and the addition of value to real property. And in the grand scheme of things, it would be chilling from an economic perspective to limit a priority security holder's interest simply by the passage of time. Now,
well, was 10 years long enough?
Well,
seriously, because we've taken in, and there's been consideration about recession, would 15 years be, appropriate?
What I've come to understand with 30 years hindsight from the law school experience is that the Uniform Commercial Code really does make sense if both parties are presumed to act in their best economic interest. And in this particular case, it's in both parties' economic interest to get this property leased. Judge Aceto below, who was either the third or the fourth trial judge that we had, actually had an evidentiary hearing where he determined the split of rents that would inure both to the trust and to Mills. And in round numbers, the trust is to receive 64% of any revenues that are achieved, and Mills is to gain the balance for the balance of the term of the original lease. So both sides are economically motivated to get a tenant in here, as you've referred to, Judge Port.
What is the balance of the term of the original lease?
It goes to 2028.
I thought it was a 15-year lease.
I remember the 2028 number, but I thought I also remembered a 15-year number, which would be right about now.
There was an option to renew, and in I believe it was Judge Garcia's findings of fact, she specifically referred to the 2028 as the end term for the lease.
Isn't there a different interest, though? Presumably, Mills amount, does that take priority, the amount for the land compared to, they have, their interest in the building, the fixtures has been subordinated to the trust. But if rent comes in, does that go first for the land? Does it go, how would it be allocated? And my question goes to, does Mills just have an incentive to try to get it rented out for a bare minimum, at least to cover the rent? Aren't there different interests between the two parties there, as between the two parties?
I'll try to answer those in the order that you posed them. As rents are received, they are to be distributed upon receipt. If it's a dollar received, 64 cents would go to the trust, and the remaining 36 cents would go to Mills as rent payments are received. In regard to Mills' desire to get anybody in there at any price, in fact, that has not been the history of the case. What led us to the final judgment that is before the court today is a proposed tenant was nominated by the trust, and there's nothing in the record below that would indicate that the lease amount was not at market rate, but Mills just flatly rejected it. So there are other considerations that go into what tenant will go into that property apart from the rent to be paid, and that's what really led us here. Both sides are obligated, according to the Uniform Commercial Code, to act in a commercially reasonable manner. Whether or not market rent is offered by a proposed tenant is first to be decided by Mills and the trust. In the event of a disagreement, regrettably, we must go to the trial court, which is what we did here. Mills seems to take the position that we get one bite at the apple, that we proposed a tenant, they rejected it, and that's it, that our security interest has expired. I'm particularly sensitive, Judge Portley, to the notion that when a case gets this old and hairy, that there's at least a tendency for courts to want to just put a wood stake in its heart and finish it for everybody's sake. Regrettably, we had this building in litigation and have had it in litigation for 10 years. And during that 10 years, we suffered the greatest economic, you called it recession, I'll call it depression, known in the history of the state of Arizona. That's out of the trust control, that's out of Mills' control.
But why is that necessarily relevant to your client's security interest in the property? At the time someone defaults, you have that collateral. And is there some requirement, what creates a requirement that you wait until that everyone wait until the economy comes back? It seems like it's your collateral now, and why shouldn't you just be required to sell it at whatever you can get for it at that point and let people move on? And if Mills wants to bulldoze the property and do something else with it, they can. Presumably you take all of your collateral.
I appreciate the question. That isn't the deal that we cut with Mills 11 years ago. That isn't the deal that we cut. There was this piece of land that Mills was not willing to finance any construction on. And my client, who was the predecessor to the original lender, agreed to make a loan to the then Bennigan's restaurant operator, conditioned expressly on Mills agreeing to subordinate every single interest that they had in that building to us. That's the deal that we did. Now, 10 years down the road, 11 years down the road, it doesn't look like such a great deal for either side. But that's the deal that we have, and that's the contract terms. So we're not obligated to do it. The Uniform Commercial Code provides that we have, that is, the trust has the ability to dispose of that property in a commercially reasonable manner. We could have just picked it up and taken it off. We're entitled to do that, but we're also entitled, which is what Mills 2 said, to dispose of the property by renting it, by leasing it, because that's what 4796
renting it
says.
at whatever the prevailing market rate is at the time, as opposed to we've got to wait until we can get until the economy rebounds and we can get a greater rent?
No, not at all. I mean, the truth of the matter, Judge Cantani, is that we didn't have any nibbles on this property until late in the game. Nobody was really anxious to lease this property. We had a broker, he made reports. Mills brought numerous motions to terminate our security interest because too much time had gone by. Judge Garcia specifically found in her ruling in 2010 that the trust was acting in a commercially reasonable manner and trying to rent this property. So we weren't sitting on our hands just waiting for the market to improve. We were trying. There just wasn't anybody buying.
But you're objecting to any time limit.
Well, it has to be a reasonable, there have to be reasonable efforts that are made by the trust to dispose of this property by leasing it. That's what we're entitled to do pursuant to the Uniform Commercial Code and our agreement with Mills. As long as we continue to make commercially reasonable efforts, then our time limit is not subject to a hard and arbitrary deadline such as January 31, 2012. I mean, as I read Mills 2, that's exactly what you said. Mills' epic answering brief, its 53 densely written pages, argues that the trial court, despite the language in its March 9, 2012 judgment, really meant to say that the trust failed to dispose of its collateral in a commercially reasonable manner. And they're able to frame the argument in this way only by ignoring the trial court's findings to the contrary, which includes Judge Garcia's June 28 findings that the trust was acting in a commercially reasonable manner, and, of course, Judge Duncan's finding that in this particular case, with this particular tenant, that the use that was intended by this particular tenant was not compatible with the scheme that Mills has for Arizona Mills. She specifically referred in her final judgment to incorporating into it the previous rulings by the judges who went before her, which included, of course, the erroneous belief that the law of the case was that that Mills 1 said that our security interest could expire upon the passage of a reasonable amount of time. So it's inescapable that when you unwind it, what happened at the end was Judge Duncan felt, and I don't say this pejoratively, she felt duty-bound to honor the previous judge's rulings that our security interest would expire on January 31, and that's what led to this appeal. What we're asking the court to do is to reverse the final judgment entered on March 9, 2012, in which the security interest of the trust was declared to have expired and that the trust has no remaining interest in the collateral. We're asking you to confirm the trial court's priority security interest in the collateral. We're asking you to instruct the trial court, if necessary, to determine commercial reasonability on a case-by-case basis of any future tenants proposed by either party, but rejected by the other. We're also asking that you award the trust attorney's fees and costs for the appeal pursuant to the written contract between the parties, the applicable statute, and of course Rule 21.
Thank you.
Good morning, Your Honors. May it please the Court, my name is Andrew Federhar with Fenimore Craig, and I represent Arizona Mills. I'd like to start by positing a question and then addressing some of the issues that Mr. Paddish raised with you this morning and things that he talked with you about. What exactly...
So it'll be a rhetorical question.
It'll be a rhetorical question. Exactly, Your Honor. What exactly is it that the trust says that the trial judge did wrong? The trust says that the trial judge started from the wrong premise, that its security interest can expire at some period in time because that's one of the factors in 479610. Today, for the first time, the trust has acknowledged to you that, in fact, its security interest does not last forever all by itself. The trust just a few minutes ago said to you its security interest lasts so long as it's acting commercially reasonably. That's a concept that hasn't appeared in its pleadings or the briefs before this court until the admission that you just heard from Mr. Paddish.
So shall we remand to have that litigated then?
I hope not, Your Honor, and I'll explain to you why I don't think that's necessary. When this court issued its opinion last year...
But only if I submit my resignation. So I don't have to see this case again, okay?
I wouldn't want to be the cause of that, Your Honor. What Judge Duncan did was actually a pretty thoughtful and good process that recognized the law that this court then later wrote about in Mills 2. The trust lacks anything in its briefs to this court describing how Judge Duncan did not follow your direction in Mills 2. The fact that you hadn't issued the opinion,
He preceded it.
well, she preceded it, Your Honor, but she did exactly what you told her to do because that's what the law required. And the trust does not tell you anywhere in its briefing to you what Judge Duncan did wrong, other than she believed at some point in time the trust security interest could expire. Now, I want to get rid of one point real quickly. Mr. Padish, I'm sure, inadvertently misrepresents to you what Judge Garcia's ruling was about how the trust was acting. All Judge Garcia said was that the trust was acting reasonably in hiring a broker to market the property. That was the extent of her ruling, not that in all other aspects of how they dealt with disposition of the property, they were being reasonable. And that was kind of a foregone conclusion because Judge Aceto had ordered the trust to market the property through the use of a broker that both parties ultimately approved of. So,
I remember this now.
coming back to you, so that's why the concept that the trust was acting commercially reasonable as to all aspects was never before Judge Garcia. It was merely that the marketing of the property through a broker was commercially reasonable.
Has it been litigated? I should know the answer to this, so I apologize that I don't, but has the specific question been litigated in the Superior Court as to whether there came a point in time when the trust stopped acting commercially reasonable and therefore, after some reasonable period of time, we're going to cut this off?
Not framed in exactly the words that you're putting, Your Honor, and I don't want to misrepresent anything from the trial court record. But what were the factors that go into commercial reasonability? Well, that's what you told the trial court in Mills 2. How they're doing it, the terms they offer, how they're managing it, what their results have been. Because someone can try earnestly to do a good job and just not succeed. That doesn't mean that they continue to try earnestly and unsuccessfully forever. And that's the point that I think we've gotten to in this case. So what Judge Duncan saw and concluded were the following things. Number one, the trust acknowledged that for a couple of years, it put the marketing of this property on a hiatus because it was prudent not to market during the economic downturn that was so deep here in Arizona. Goes to your question, Judge Catani. Do you have to wait until the largest amount of money can be gained, or do you market based under the conditions that exist at the time that you have your collateral? The trust chose not to market. In fact, they stopped filing marketing reports with the trial court because there was nothing to say. So that was one issue that Judge Garcia and then Judge Duncan later on considered. Number two, the trust rejected two tenants, one of whom offered a higher rental rate than the trust tried to force on Arizona Mills in January of 2012. They rejected it. Number three, the way the trust acted. Contrary to what the trust says to you today, we got take it or leave it propositions at the trial court. In 2011, we had one from an operator of something that would have been called Ala Moani Tahiti, I think I'm saying that the right way, which would have been a Tahitian-themed restaurant, and even the trust in their opening brief acknowledges that was not a viable, not commercially reasonable, wasn't even viable tenant. Yet we had multiple motions in front of the judge to try and force that lease on us. Then we come to January of 2012, and another tenant shows up, and they forced the same terms on us. We had objected to the division of rent in terms of paying for commission and upgrading the facilities. We objected in 2011. We objected again in 2012. The trust never offered to change those terms. So Judge Duncan, saw that the trust was acting unreasonably and how they were marketing and trying to force the property into a lease that we would not agree to. The exact same terms. It was ironic that in court, in front of Judge Duncan, the trust offered to modify some of those terms on the record for the first time. And Judge Duncan was pretty frustrated with that because they were not communicating with us. Both Judge Garcia and Judge Duncan had ordered the trust to work with us, and both judges found that the trust was not working with us. So while it may be commercially reasonable to hire a broker, it's not commercially reasonable not to communicate with the people who actually own the land and own the building. Now, Mr. Padish talked a lot about this wasn't the deal the parties struck, and I couldn't agree with him more. Back in 2000, when the subordination or the consent was signed, the law was a creditor had the right to remove it, to sign a new lease, to sell it in place, or I suppose to walk away from it. It was only until after the UCC changed in 2001, a year later, that a creditor got the right to lease it in place. So part of the consideration that we think the trial judge played was that it wasn't the deal that the parties negotiated back in 2000 for them to be able to use our unencumbered land without compensation in an effort to recap 100% of what they loaned to the debtor, to the defaulted restaurant operator. And that's what their position is in front of this court. They boldly state it in their reply brief that their security interest lasts until they're repaid in full. The UCC is not a guarantee. The UCC is a means by which parties to a bad business deal can mitigate their losses, and it sets forward the structure within which that happens. To hold otherwise makes every landowner who agrees to subordinate their landlord's lien to a creditor the guarantor that that creditor is going to get 100% of their money back. That wasn't the deal they struck. That would have made their loan risk-free. And the interest rate was astronomical. It was a double-digit interest rate. And in answer to your question, the loan documents expired in 2015, not 2023 or 2028, a later date. The loan documents by which the trust expected to be repaid on the building were 2015, and on the equipment has already expired several years ago. So how can they have an expectation of being repaid when their loan on the equipment, some $400,000 plus, is already expired, and their loan on the building will expire in 2015? It just doesn't make sense. ARS Section 47-9610 is based on the Uniform Commercial Code. And the Uniform Commercial Code has a comment to it. And it's a very clear comment, and it's one that the trust ignores. And we cite it to you at page 43 of what Mr. Padish complained about as our long and tedious brief. UCC comment 916, comment 3 says, if a secured party does not proceed under Section 9620, the process by which they accept the collateral as partial or full payment of the debt, that wasn't done here. So if they don't proceed under that section, and they hold the collateral for a long period of time without disposing of it, and if there is no good reason for not making a prompt disposition, the secured party may be determined not to have acted in a commercially reasonable manner. That's what Judge Duncan and Judge Garcia were talking about when they looked at the effect of the recession on the marketplace. And they analyzed when the market would be suitable for marketing the property and then how long it would take to market the property. Remember, we had an expert, Gladstone Gregg, their expert, who said commercially reasonable time to market 6 months. Now, he was talking about 2003 when we were in a normal market, all right? But presumptively, by the time you get to the end of the recession and a recovery, we're back in a normal market.
Are we?
That was the determination of the trial judge, and that determination has not been challenged here on appeal. So for this case...
It's very comforting for me to know this.
Well, isn't it good for the value of your home, Your Honor? But for the purpose of this case, the judge made a determination about when the market had returned to normal, and she gave them 7 months, not 6 months, but 7 months' time to market, an additional month beyond what their own expert said you would have a reasonable expectation of having a new tenant. So you start to look at all of these additional factors, and it's clear the trial judge didn't make her determination solely on the basis of the passage of time. So for this court, I think there are two issues for you to determine today. One, can a security interest created by consent last forever or until the secured creditor is paid 100% of their loan? And the answer to that is a resounding no.
Can it last forever?
That's what their argument is, Your Honor. If we keep bringing in a succession of tenants and they fail and their loan doesn't get paid, they get to go on, maybe not forever, but for a heck of a long time until they get that loan paid. They're owed over $1 million. And so, you know, when you look at a rental rate, and the last rental rates were in the $20 a square foot range, and they get approximately 2/3 of that, that's not a lot of money that's going to make a lot of dent in that debt. So you,
Sorry, it could go on forever, assuming they paid some rent for the land. Would they not be entitled to just sit on the property and decide forever whether now is a good time to sell?
well, you know, Your Honor, if they paid some rent on the land, we wouldn't be here.
And that goes, I guess, and I apologize for not, this may be somewhere in the record, but the original deal, did it specify there is some amount that goes to rent for the land, some for the property? Was that ever proposed to the trust that if you pay this amount, we don't care what you do, you can sit on this forever? And
Yes, precisely correct, Your Honor. The original deal was there was a lease with Mills and the tenant, and the tenant paid us the lease. There was a second deal where the tenant paid the trust for the loan. They were never wrapped together, so there were two separate payments. They totaled over $53 a square foot by the time you put them together. Remember, the trust expert said the fair market value in 2003, at the time of default, was $32 a square foot. So
there was a specific amount for the
Yes.
lease for the land that
Absolutely.
presumably could be paid.
And so we demanded of the trust at the time of default that they either sign a new lease with us, take over the old lease for the defaulted tenant, or move their equipment off, move their material off. They rejected all of those, opting for the new remedy that had become available to them in 2001 and the UCC to be able to lease. Now, we argued to this court, unsuccessfully, that new UCC section shouldn't be retroactively applied. So we can't go back and re-argue that issue for you today, although it still stings a little bit. But that's the point, Your Honor. We offered them their remedies, and those remedies included signing a new lease, paying the ground rent, and then they could have done whatever they wanted to with the collateral. Repeatedly during the course of the litigation, we said, look, guys, if you don't want to pay us rent, pick up the collateral and take it. You can have it, even though we own it. You can take it. They refused to do that, judging that it was more likely they could generate revenue by leaving it in place. That's their decision. But that goes into the question of what's reasonable, because we have a piece of land that for over a decade, without a security interest in, the trust has been able to prevent us from getting any economic return on. And that goes into the question of whether under 9610 we have a commercially reasonable period of time. So this is where you're left, Your Honors. 47-9610, and that's the statute that applies. You'll note that Mr. Pattis started off by talking about 9334. That statute has no application to what we're here to talk to you about today. Under 9610, all aspects of the disposition of collateral have to be commercially reasonable, including, among others, time. And it's been enough time. It's been 10 years. If you remand this case to the trial court, what's the trial court going to do but otherwise send it some decision that's going to come right back here for Mills 4, and Judge Portley's just going to have a hard time staying on the bench. He may resign over this case, and we don't want to be the cause of that. If the trust truly had wanted this case decided after Mills 2, they had Rule 60C relief available to them. They could have asked the trial court to reconsider its judgment under Rule 60C because of your opinion. They could have asked for a stay at this court and pursued that. But instead, they continue to engage in a pattern of activity to drag this out and try and essentially force us to buy out their interest so that we can gain control of our unencumbered land. Because as long as that building sits on that land and they have a security interest, we are powerless to do anything. The trial judge said they have total control over the marketing of the property. We don't. So we can't even market our own property as long as this security interest exists. Sending this case back to the trial court means we're back here in 2 years, arguing in front of you or maybe your replacements if Judge Portley holds true to his threat. And that's not in anybody's economic interest. There's not a case in this country recognizing a security interest that's lasted a decade after default. This shouldn't be the first one. We'd also like our costs and fees. Thank you, Your Honor.
Judge Gemmell or Judge Portley, I forget which one of you first raised the question of how long our security interests last in the property, and I'm sure that Mr. Fedahar misremembered the record in this case when he told you otherwise. Judge Garcia found in her September 19, 2011 minute entry ruling in regard to the trust motion for clarification, she specifically found that, and I quote, "The plaintiff should continue to negotiate with prospective tenants and is empowered to enter into a lease for a term beyond January 31, 2012. As for the length of time it may earn income, the court finds that 2028, the original date for the termination of the lease, is appropriate." Let me now start with where Mr. Fedahar left off.
Well, but that's the court just saying that if, in fact, a tenant is secured, you could enter into a lease beyond the lease term, and the new lessee could have a lease through 2028, and you, the parties then could then split up the monthly payments according to her schedule.
Well, it got a little tilted, frankly, Judge Portley, in that when this January 31, 2012 judicial pronouncement that the recession had ended and our security interest would expire, the question came up with, well, we're negotiating with prospective tenants. Can we enter into a lease with them after January 31, 2012? And that was the purpose of the motion for clarification, and what Judge Garcia made clear is, yeah, we can enter into a lease with them up to 2028, which is what we were originally entitled to. Mr. Fedahar did a artful job of sidestepping a question that you posed to him. The trust never entered into a lease with Mills. It was the original Bennigan's operator who had the lease with Mills. We weren't part of that deal, and we still don't have a lease with Mills. Rather, what Mills agreed to was that we would have a security interest in the collateral that was on that property. Mills asked us when the tenant defaulted to cure the default and step into the lease, and we exercised our rights under the UCC and our contract with Mills to not do so. They locked us out of the building. That was part of Mills 1. They brought a forcible entry and detainer action. That was part of Mills 1. Part of Mills 2 was they actually brought a counterclaim against us for trespass, making the incredible argument that the trust was trespassing on their land by having the building owned by Mills on Mills' land. Of course, that was an argument that was rejected by this court. The argument that Mr. Fedahar makes that Judge Duncan, the last trial judge in this case, made a determination that the trust was not acting commercially reasonable isn't supported by the record. The final judgment that was entered in this case was actually drafted by Mr. Fedahar, and it's included, of course, in the papers. It was filed March 9, 2012. And it says, pursuant to the court's September 16, 2010 judgment, which would be the trial that was held before Judge Garcia, in the orders of the court on May 16, 2011, in which Judge Garcia set January 31, 2012 as the termination date for the trust security interest, and the February 9, 2012, there are no remaining orders. It's inescapable that Judge Duncan considered herself bound by what was then the law of the case, because Mills 2 had not come down, and said in so many words that our security interest had sunsetted. What Mills is trying to do is like when you pop a shot off into the side of a barn, and you go up and you put a circle around it and you claim that you hit a bullseye. That's what they're saying happened here with 9610, that Judge Duncan made all of these findings, when in fact she didn't. We didn't even have an evidentiary hearing to discuss the issues that are set forth in Mills 2 regarding commercial reasonability.
But Judge Duncan did not just issue a ruling saying the date has passed, therefore property now goes to Mills, did she?
No, she said, and again, it was based upon what Judge Garcia had done before her, and also implicitly, because she referred to Judge Garcia's minute entry, what Judge Aceto had done in setting a in saying that the law of the case was based upon an erroneous interpretation of Mills 1, that our security interest could expire simply by the passage of time. That later was found by this court to not be the law. Mr. Fedahar failed to explain to you why it is that the trust was given the exclusive ability to market the property, and it's really contained in Judge Garcia's findings of fact and conclusions of law in September 2010. What was happening was we were supposed to market it, and this is in the record, we were supposed to market it jointly, and Mills was playing hide the ball with us, and they were negotiating with tenants secretly and then presenting us with signed letters of intent. And at that point, then I believe it was Judge Baca gave us the exclusive ability to market the property. There is nothing in the record below that supports the contention made by Mills that the trust put this property into hiatus for years, waiting for the market to recover. I mean, the trust is, if anything, an economic animal, and it is not the trust's best interest, nor to Mills, to let this property remain idle.
What's your bottom line as to when this period would end? Could you just go on forever? Just, in your view, behaving in a commercially reasonable manner, you could nevertheless not enter into a lease and Mills just has no remedy?
No, quite to the contrary. The market will tell us when this property may be leased. That's what the UCC contemplates. That's what in the broader sort of 30,000 feet looking down view of the world is supposed to happen in the contractual relationship between the trust and Mills. Of course, during the Depression, there wasn't much interest. As we started to gain a slow recovery, there were some, as I said before, nibbles. And the most recent one that we had was this one that was rejected by Mills for reasons apart from the market, apart from the price is not enough, the term isn't good enough. I mean, they rejected it.
Okay. Well, you've run out of time, and I think we understand your position, so we will take this matter under advisement, issue our ruling in due course, and we stand adjourned.
Thank you.
we turn off the microphones?
Yeah.